Good morning. As the Chair just said, my name is Andrew Eccleston. I'm the Deputy Chair. I'm also an Adjunct Senior Research Fellow at Victoria University and a former Senior Investigator in the Office of the Ombudsman. The Council has no position on the Gene Technology Bill as a whole, as you would expect from a Council on Civil Liberties. What we do have is a position on the insertion of yet more clauses into legislation that oust the Official Information Act. The Council objects to the secrecy clauses in this bill, in clauses 59 and 151, as these will unjustifiably limit the public's right to information as guaranteed by the Official Information Act. These provisions matter because they will damage public trust in the regulatory regime for novel gene technologies. The 2024 Edelman Trust Barometer, which measures trust in issues around the world, looked at public trust in novel technologies and scientific innovation. They found that 58% of the public reject GMO foods and 34% reject gene-based therapies. And to counter this, they recommend greater openness, not less. To build trust, people must have confidence in the regulatory regime, and secrecy undermines this. As drafted, Clause 59 ousts the OIA for information held by the relevant agencies that is likely to relate to an application for a license or for a Section 12 determination before an application is submitted. This ouster of the OIA is not justifiable. It is not considered in the regulatory impact statement. It's not mentioned in the Cabinet Papers or the vetting of the bill under the New Zealand Bill of Rights Act. It is only in answer to question 4.9 of the Departmental Disclosure Statement that MB provides a rationale. It says, this limitation is necessary to protect confidential information while an application is being developed and to avoid discouraging pre-application engagement with the regulator. And it's relevant that question 4.9 asks whether the bill contains any provisions that are unusual or call for special comment. And the provision is more than unusual. It is, in our experience, unprecedented. MB and the government's claim rationale for this clause does not withstand scrutiny. The reason that it's an unnecessary provision is that the pre-application information that the clause relates to is already protected by Section 92B of the OIA, which states that information can be withheld if it's necessary to either protect a trade secret or because disclosure would be likely to unreasonably prejudice the commercial position of the person who supplied or who is the subject to the information. And there is a second withholding ground in the OIA that is relevant. 92BA of the OIA says that information can be withheld if it is necessary to protect information subject to an obligation of confidence, where disclosure would prejudice future supply. So in other words, there are already provisions in the OIA that cover the circumstances of pre-application supply of information and interchange with the regulator. There is no need to oust the OIA. The OIA has ample provision for this. So the Council recommends that subclauses 59.2, 59.3 and 59.4 are deleted from the bill. There is also a problem with Clause 151 of the bill. Clause 151.5 enables information sharing between agencies, but allows the imposition of conditions the agency thinks fit relating to the disclosure of the information that's being shared. This could lead to claims that a statutorily backed obligation of confidence has been created when information is shared between two government agencies and thus override the OIA. Further, under the OIA, ministers and agencies are only able to impose conditions on the use of information if good reason exists under the law not to disclose to the public. So, taking that in slightly more detail, if Clause 1515 allows information to be kept confidential, agencies could then argue that Section 90B of the OIA is engaged, which protects information subject to an obligation of confidence. Government cannot normally owe a duty of confidence to itself, but the explicit provision in Clause 1515 may override that, effectively enabling the government to contract out of the OIA. Second, the Ombudsman has been very clear on multiple occasions that conditions on the use or sharing of information released to a requester can only be imposed in circumstances where there is good reason under the OIA to withhold the information from the public in general. So the Council recommends that in Clause 151 you add a subclause that states nothing in this section limits the Official Information Act 1982 or the Local Government Official Information Meetings Act 1987 or the Privacy Act 2020. The secrecy clauses in this bill exemplify the issue we highlighted in a briefing to the Minister for Public Service in 2021, where we said that there had been more than 30 secrecy clauses enacted by the last government already. All too frequently, these secrecy clauses are inserted into new legislation, and MB, the department behind this bill, is one of the worst offenders. Later this week, I will be speaking to another select committee about the Offshore Renewable Energy Bill, where it has also inserted a secrecy clause. In many cases, these clauses are inserted to try and provide a guarantee to companies that their information will never be disclosed. Instead, agencies should be reassuring companies that the OIA already provides adequate protection. Besides shutting out the public and fostering distrust and suspicion of a captured regulator, these secrecy clauses send the message that the government does not trust the Ombudsman. The committee should reject this attack on the OIA and amend the bill as we recommend. Happy to take your questions.
Deborah, you've got submission.
Yeah, reverting to clause 59.
Yep.
And you're suggesting the OIA already covers that stuff.
Yep.
Do you think it might be more effective if there's a specific reference to the OIA in there?
The problem here is that 59.3 specifically says the OIA does not apply to that information until the application is received by the regulator. So it's specifically carving out this pre-application exchange of information between a potential applicant and the regulator. Now, we can understand why companies and scientists would want to have a pre-application discussion, because the regulator may say your application's not in good enough shape to come to us yet. If you put it in now, we'll reject it, right? Mm-hmm. But the OIA already provides ample protection for that kind of information. There's no need to carve out the OIA from that kind of pre-application discussion. Right? The point about the OIA applying is that there is a narrow window there where the Ombudsman may say in a complaint on a refused OIA request, the public interest in disclosure in this circumstance outweighs the need for confidentiality. And the point about these secrecy clauses is that government's effectively saying, we don't trust the Ombudsman's judgment on where the balance of public interest lies. Right? Now, those kind of attacks, Parliament should not be endorsing. It passed the OIA 43 years ago. It's been quite happy to live with the OIA for that amount of time, and it's been happy to accept the Ombudsman's judgments on where the balance of public interest lies. So if you knock out subsections 59.2, 3 and 4, then all you're saying is that who holds the information for the purposes of dealing with a request. And that's fine. You should clarify who holds the information because it's going to go to a couple of different agencies. But there's no need to have 2, 3 and 4 in there because the OIA amply protects that information. And agencies take a conservative approach with a small c to OIA withholding grounds and commercial sensitivity, and so does the Ombudsman. It's relatively rare for the Ombudsman to find that the public interest in disclosure outweighs this kind of information being protected under the OIA. But if the public has to have confidence in the regulator not being in too cosy a relationship with applicants, it's got to be capable of being scrutinised, and this prevents that kind of scrutiny.
Yes. Okay. Steve.
Yeah. So, I mean, essentially you're saying this leans into potential public scepticism of the transparency of government because it looks like government's intentionally trying to keep things secret.
Yeah, that's what it boils down to. That's why I quoted these figures from the Edelman Trust Barometer. Right?
Yeah.
I mean, we don't do very good surveying of public trust in this country. We tend to rely on international surveying mechanisms, and occasionally New Zealand falls off the map. That's why I quoted the Edelman Trust Barometer. If you've got 58% of the public around the world rejecting GMO foods and 34% rejecting gene-based therapies, there's a lot of public distrust in novel science, which means that the public has to be able to have confidence in the regulator, safeguarding their interest. The bill does not contain a precautionary principle. The Cabinet papers quite explicitly say we're not going to have a precautionary principle in this bill, and therefore the public has to be confident that the regulator's relationship with companies that are going to be submitting applications is not too cosy. And that's what the OIA provides a guarantee for, is that if you make a request and it's refused, you go to the Ombudsman can look at the papers and say, no, this doesn't smell right to me, and I think I need to dig further, and could find that the public interest in this case favours disclosure and outweighs the reasons for commercial confidentiality or submitted in confidence.
Very good. Very clear. Yeah. Very good submission. Thank you very much.
Secrecy clauses, what do we think?
Well, can I say this gentleman, he absolutely hit the nail on the head.
Mm-hmm.
In August, G3 New Zealand wrote to actually ask for a whole lot of information that informed the new bill that we didn't know was going to come on. And lo and behold, we did not get any reply to it. We had to go to the Ombudsman. We got the reply last week. And the most vital information, which was this Technology Advisory Committee that Saraya mentioned, which is totally embedded in people who will benefit from this bill being passed, either with patents, either with being able to use the GE product or whatever. Now, in this, the Technological Advisory Committee actually was totally redacted. 7 pages of this information of 158 was just redacted, and all the rest was just kind of preamble of how they were in their meetings, because it was all meeting data. So in the end, what we do know is that actually the Ministry of Business, Innovation and Employment are already using this technique. And we are more and more having to go to the Ombudsman. So bang on, and I thank this gentleman for Civil Liberties to actually raise this, because it is highly, highly important that we as a democratic and also submitters who need that information to make informed decisions have that information, so we don't look silly when we present. So, yeah, I would like to congratulate him on an excellent submission. And I felt the question that Steve asked was pertinent. Yeah.
Yep, he absolutely nailed it. And I just loved his, I love it when they just churn out all this stuff really fast and lots of numbers and lots of, like, you know, they sound really like they know their stuff, and it just comes out, and he was going for it, which was wonderful. Now, what someone I know always says this, she always says, politicians are the highest paid beneficiaries in the country. And, you know, they have to realise that they are public servants. Everybody that works for a government department, no matter how high up you think you are and how well paid you are being paid by the people. So it's your job to work for the people. And there's so much secrecy in this bill. It's ridiculous. What amazes me is that lawyers aren't just coming right out, and he virtually did, which was wonderful. I'm not sure if he's a lawyer, but he speaks like one. And say, well, this is just so defective in terms of a piece of legislation. It just can't function. You know, there's so much in it that's just not functional. And he was great. He just picked all the fundamental faults out and yeah, took the government to task, which is, we need more like this. It's wonderful. So yeah, congratulations to him.
Yeah, really, really good submission. He was going so fast, he could have given Eminem a run for his money.
Yeah.
Okay, so the next submission.
Put some music
Oh, yeah,
behind it.
yeah, make a remix. Okay.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok, News Scout, the Order Paper Podcast. YouTube, Twitch, Instagram.